My name is John P.L.L.C. I'm a Florida probate litigator with the P.L.L.C. law firm in West Palm Beach, Florida. Today I'm going to be speaking to you about 3 affirmative defenses that you need to know about if you're engaged in a petition to revoke probate, in a tortious interference with an inheritance lawsuit, or any other type of probate litigation or estate litigation in the state of Florida. Now, most of the time we think of someone filing a petition or a complaint in the context of an inheritance, or maybe there's a dispute about a joint account with the right of survivorship, such as a bank account, or maybe homestead litigation. And we usually answer that petition or that complaint. But what's also important, in addition to admitting or denying the allegations in the complaint in the form of the answer, is your affirmative defenses. And many probate lawyers who don't handle estate trials or trust trials or probate litigation in Florida aren't familiar with the Florida rules of civil procedure and the more defensive tactics to probate litigation. Many probate lawyers are very well versed in the probate code, the Florida probate code, as well as the Florida probate rules. But less so perhaps in the strategies of trial work, the mindset of litigation, as well as the Florida rules of civil procedure and Chapter 90, the evidence rules. So we're going to speak today about 3 important affirmative defenses that you should know about if you're engaged with a Florida probate lawyer in the middle of an estate or trust lawsuit. First of all, the concept of estoppel. You can have equitable estoppel or judicial estoppel. Then I'm going to speak very quickly about waiver. We should understand, first of all, that affirmative defenses are not denials. I've seen certain probate litigators prepare affirmative defenses that are not affirmative defenses. Affirmative defenses are yeah, but. Yes, even if your allegations in the complaint are accepted as true, I've got an excuse. I've got a way out. There's some reason why I'm not responsible. That's an affirmative defense. Yes, but. A pure denial is not an affirmative defense and can be stricken. So when we look at the Florida rules of civil procedure, we do see examples in the rules of affirmative defenses. One of them is estoppel, where you're prevented or you're stopped from asserting a particular legal position. What most people don't understand, and what most probate lawyers in Florida don't understand, is that there's 2 types of estoppel. One is equitable, one is judicial. What is the difference? Well, judicial estoppel prevents a party from taking one side of the case or asserting one particular legal position on a Monday in one proceeding and getting finality or a judgment, and then coming back into another courtroom in some other proceeding in Florida and taking a different position. That is prohibited in Florida. And one of the reasons that judicial estoppel is an effective affirmative defense is it's to prevent people, litigants, from taking inconsistent positions, and it's to uphold the integrity of our judicial process and our civil procedure. Otherwise, people could be taking 10 sides to every story and filing 10 different lawsuits and never really being convicted with their allegations or convicted to their allegations. So that's judicial estoppel. If something is adjudicated in one proceeding and you've got a judgment on it, and you take one position, you can't then later take an inconsistent position in another judicial proceeding. Judicial estoppel. That's different than equitable estoppel. Equitable estoppel is when someone makes a representation to a material fact that is contrary to a later asserted position. Somebody needs to rely on that representation, that change of position, and it has to be detrimental to the person that's relying on it. So here you need actual reliance and relying to one's detriment for equitable estoppel. You told me this. You promised me this. You knew I wouldn't do this because of your promises. I relied on you, and because of that I was harmed. I acted to my detriment. That's an example of equitable estoppel. Much different than judicial estoppel. Finally, waiver. What is waiver? Waiver is a voluntary and intentional relinquishment of a known right. If you knowingly give up something, if you say you don't want to do something, and it's done voluntarily, you can't come back at a later time and try to make a claim regarding that. you've waived those rights or that claim. Equitable estoppel, judicial estoppel, waiver. Three important affirmative defenses that are often overlooked by Florida probate lawyers when you're in the middle of trust litigation, guardianship litigation, or estate litigation. My name is John P.L.L.C. I practice probate litigation in West Palm Beach, Florida. We handle all matters regarding appeals, trials, and administration of wills, trusts, and estates, as well as guardianships. If you want to read about these three affirmative defenses, you can check out the October 28, 2009 opinion from the 4th District Court of Appeal. The 4th DCA is the appellate court which hears probate, trust, guardianship, and civil appeals, as well as criminal, for Palm Beach County, Martin County, and Broward County. In the Bueno v. Workman case, B-U-E-N-O v. Workman, the site is 20 Southern 3rd, 993, a 2009 4th District Court of Appeal, Florida case.